Georgia has a landlord-friendly breaking lease framework with minimal state-level regulation and strong preemption provisions that prevent local governments from adding requirements. The governing law is found in Georgia Code Title 44, Chapter 7, which covers landlord and tenant relations, along with general contract principles. If you're a landlord or tenant in Georgia, the state gives landlords broad discretion while recognizing the basic duty to mitigate. Let's start with the landlord's duty to mitigate damages. Georgia law recognizes the landlord's duty to mitigate when a tenant breaks a lease and vacates. This duty is established through Georgia case law and general contract principles. The landlord cannot leave the unit vacant and hold the departing tenant liable for the full remaining rent without making reasonable efforts to re-rent. The landlord must take reasonable steps: advertising, showing, and accepting a qualified applicant. The departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. If the landlord fails to mitigate, the departing tenant's liability is reduced. Georgia's mitigation duty is based on case law rather than a detailed statute. Courts evaluate reasonableness on a case-by-case basis. The local market conditions, property condition, and the landlord's typical practices all factor into the analysis. In Georgia's generally strong rental market, particularly in the Atlanta metro, landlords can typically re-rent within a reasonable time frame. Georgia's preemption statute, Section 44(7)(19), limits local governments from regulating certain aspects of the landlord-tenant relationship. This ensures statewide uniformity. No Georgia municipality has enacted local provisions that add breaking lease requirements beyond state law. Atlanta, Savannah, Augusta, and every other Georgia community operate under the same framework. Early termination clauses are generally enforceable in Georgia. The state does not cap early termination fees. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable. Georgia courts enforce reasonable contractual provisions and give deference to negotiated terms. A grossly excessive fee could be challenged as an unenforceable penalty. But Georgia's legal culture generally favors freedom of contract. Many Georgia landlords, particularly large property management companies in the Atlanta metro, include detailed early termination provisions that specify different fee amounts depending on how far into the lease the break occurs. For example, a lease might specify 2 months' rent for termination during the first 6 months and 1 month's rent for termination after 6 months. This graduated approach is enforceable and reflects the reality that early breaks cost more because the landlord has less time to recoup turnover costs. Military members have the right to break a lease under the SCRA. Georgia has a substantial military population. Fort Eisenhower, formerly Fort Gordon, near Augusta, is home to the Army Cyber Center of Excellence. Fort Moore, formerly Fort Benning, near Columbus, is one of the Army's largest training installations. Robins Air Force Base near Warner Robins is a major Air Force logistics center. Moody Air Force Base near Valdosta, Fort Stewart near Hinesville, and Hunter Army Airfield in Savannah generate additional military demand. SCRA lease terminations are a regular occurrence across Georgia's military communities. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Fort Moore's training mission creates particularly high turnover. Thousands of soldiers complete training programs and move to their next assignment throughout the year. Landlords in the Columbus-Phoenix City area process enormous volumes of SCRA terminations. Fort Stewart's deployable units generate deployment-related SCRA breaks. Landlords near any Georgia installation should have streamlined SCRA procedures. Georgia has enacted protections for victims of family violence that allow early lease termination. Under Georgia Code, Section 44(7)(23), a tenant who is a victim of family violence, as defined in the Family Violence Act, can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation must include a copy of a temporary or permanent protective order or a copy of a police report documenting the family violence. The tenant must provide at least 30 days written notice before the termination date. When a family violence victim terminates under this provision, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit is handled according to standard rules. Georgia's provision also addresses situations where the perpetrator is a co-tenant. If the victim and the perpetrator are both on the lease, the victim can terminate their individual obligation. The remaining tenant's obligations continue, and the landlord can pursue lease enforcement or eviction against the perpetrator. Tenants in Georgia may break a lease if the landlord fails to maintain habitable conditions. Georgia recognizes an implied warranty of habitability in residential leases, established through case law. The landlord has a duty to maintain the premises in a condition fit for habitation. If the landlord fails to address serious deficiencies after receiving proper written notice, the tenant may terminate. Georgia's habitability framework is less detailed than states with comprehensive statutory repair and cure processes. The standard is reasonableness. The tenant must provide written notice, allow a reasonable time for repair, and document the conditions. If the landlord fails to act and the conditions are serious enough to substantially interfere with habitation, the tenant can terminate. Georgia also recognizes constructive eviction. If the landlord's failure to maintain the property or affirmative actions, shutting off utilities, changing locks, failing to address dangerous conditions, render the unit uninhabitable, the tenant can treat the lease as terminated. The tenant must vacate within a reasonable time. Georgia has specific provisions regarding security deposits that affect the breaking lease context. Under Section 44 Tier 7-30 through 44 737, landlords who own more than 10 units or use a property management company must place the deposit in an escrow account and provide specific disclosures. Failure to comply with the escrow and disclosure requirements can result in forfeiture of the entire deposit and potential treble damages, even if the tenant broke the lease and caused damage. This means a Georgia landlord who doesn't comply with the deposit requirements loses the right to retain the deposit when a tenant breaks the lease, regardless of the tenant's breach. Deposit compliance is essential for preserving your right to recover damages from a departing tenant. Georgia's abandonment provisions are governed by general landlord-tenant law. If a tenant abandons the property, leaves without notice, removes belongings, and stops paying rent, the landlord can retake possession after a reasonable period. The landlord should document evidence of abandonment before entering. The departing tenant remains liable for damages subject to the mitigation duty. Georgia has a relatively fast eviction process. Landlords can pursue a dispossessory action with relatively short timelines. This fast process means landlords can quickly regain possession when a tenant stops paying rent as part of breaking the lease, reducing vacancy exposure. From a practical standpoint, Georgia has one of the largest and most dynamic rental markets in the Southeast. Atlanta is the dominant market and one of the largest in the country. When a tenant breaks a lease in Atlanta, re-rental depends on the neighborhood. Midtown, Buckhead, West Midtown, and the Beltline corridor have extremely strong demand. Re-rental within 2 to 3 weeks is typical. Decatur, East Atlanta, and Kirkwood have strong demand. The northern suburbs, Alpharetta, Roswell, Johns Creek, attract families and fill quickly. More affordable parts of the metro take slightly longer. The Beltline corridor has created particularly hot submarkets where broken leases are absorbed almost immediately. Landlords in Beltline-adjacent neighborhoods may receive multiple applications within days of listing a unit vacated by a departing tenant. Atlanta's enormous and diverse applicant pool means that the departing tenant's financial exposure is typically limited. The landlord can usually re-rent quickly in the metro's strong market. Savannah has a growing market driven by the port, tourism, escad, and manufacturing. Re-rental is moderate to quick. Augusta has a moderate market driven by Fort Eisenhower and healthcare. Columbus has a heavily military-influenced market near Fort Moore. SCRA terminations are constant. Athens, home to UGA, has a tight student market. Lease breaks time to the academic calendar fill rapidly. Warner Robins, near Robbins AFB, has military-driven demand. Valdosta, near Moody AFB, has a similar dynamic. Hinesville, near Fort Stewart, has a heavily military market. Fort Stewart's deployable units create deployment-driven lease breaks that are distinct from standard rotation breaks. Deployments can happen on short notice, and families may break leases to relocate closer to support networks during the deployment. Macon, Albany, Dalton, and smaller Georgia communities have more moderate markets with varying re-rental timelines. One best practice for Georgia landlords: include a clear early termination clause in your lease. Georgia's preemption ensures statewide uniformity, so you can use the same clause across all your Georgia properties. Consider a graduated fee structure. Higher fees for breaks early in the lease, lower fees later, which reflects the reality of turnover costs and is generally enforceable. Another best practice: comply with Georgia's security deposit escrow and disclosure requirements. If you own more than 10 units or use a property manager, the deposit must be in an escrow account, and the tenant must receive specific disclosures. Failure to comply means you lose the right to retain the deposit when a tenant breaks the lease, even if the tenant caused damage. Don't let a procedural lapse eliminate your financial protection. A third best practice: for landlords near military installations, build SCRA terminations into your business projections. Georgia has one of the largest military populations in the country. Fort Moore, Fort Stewart, Fort Eisenhower, Robbins AFB, and Moody AFB all generate massive turnover. Treating military lease breaks as routine, rather than adversarial, maintains relationships with the military community and keeps your occupancy rates high. Georgia requires landlords to return the security deposit within 1 month of the tenant vacating. Landlords with more than 10 units or using a management company must hold the deposit in escrow and provide specific disclosures. If the landlord fails to comply with the escrow, disclosure, or return requirements, the landlord may forfeit the entire deposit and may be liable for treble damages. These rules apply to broken leases and normal move-outs alike. For the complete guide to Georgia breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.